Welcome to Notable Approvals. I am attorney Amanda Schaefer. I have another exciting case to talk about with you today. Great way to start a Monday morning. Before I get to that case, don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you find this video to be helpful or know someone who may, click that share button, please. So, like I said, great way to start my Monday. I go check the mailbox this morning when I got to the office, and I had a cancellation of removal grant for two of my clients who are husband and wife. So, number one, off the bat, it is not that easy to get cancellation of removal granted for both mom and dad. And in this case, mom and stepdad. And I'll get to how in a second. I'll just give you some background information. And I know some of you out there may be watching, waiting for your cancellation of removal grants to come through and are wondering on timeline. So this will give you a little insight into timeline in New York. Both mom and I'm going to refer to mom and stepdad for a reason. That's how I'm going to refer to the clients. And you'll see in a little bit why. So mom and stepdad are both natives and citizens of Mali. Stepdad entered the U.S. in 2001 with a visitor visa, and mom actually entered a year before with a visitor visa. However, it was under a different name. They got married in the U.S. in 2009. In 2012, mom filed for asylum based on being a victim of FGM, or female genital mutilation, which is a very common claim for Western Africa. And I do a lot of those cases. However, if you've watched any of my videos or know anything about asylum, in order to qualify for asylum, you need to file within 1 year of entry, unless there is a change in country conditions. FGM claims don't really have change in country conditions. They can, but they don't really. So dad then filed for asylum a year later with the same lawyer, and this was not with us. At that time, since they were already married, he could have been on her asylum application as a derivative. I'm not exactly sure what decision-making was behind it, but I know there are a lot of people that will come to us and say, I've been in the U.S. for 10 years. Can I get a green card? And the answer is maybe. If you qualify, there's still qualifications beyond just the 10 years. And I'll get to that very shortly. So mom and stepdad have 3 children. 2 of them are together and 1 is a stepchild. And the stepchild is the key here. And I'll tell you why. Because of the requirements for cancellation of removal for non-permanent residents. Or you may have heard of it as an EOIR 42B or a 10-year green card. All the same thing. It's 10-year green card is a bit of a misnomer because it sounds like you just need to be in the U.S. for 10 years, but that is not the case. So what do you need? You do need 10 years of physical and continuous presence in the U.S. So if you entered in 2015 and you applied for cancellation of removal for non-lawful permanent residents today, you would not be eligible, based on that alone. And you have to reside continuously. You couldn't have left and came back. Second thing, you need good moral character. So, of course, for a lot of things I talk about, you need good moral character. Essentially, you don't want to have any crimes. You want to be a good person, and you need to show proof of that. If you're religious, you go to church, temple, mosque, we get a letter. If you do volunteer work, we get a letter, things like that. And if you have any criminal history, even if it's minor, you want to have even more good moral character evidence. You also have to have no other inadmissibilities. I mentioned that mom entered with a visa in someone else's name. That would be fraud and misrepresentation. Cancellation of removal is one of those types of claims where you can still get a green card without a separate waiver, because this is essentially a waiver in and of itself. So what was I saying? Yeah, so it doesn't count as an admissibility, but you can't have a prior order of removal. You can't have any disqualifying criminal history, that type of thing. And finally, the hardest requirement to meet would be the extreme and unusual hardship requirement to a U.S. citizen or lawful permanent resident, and could be a child, a parent, a spouse, and child, parent, spouse. I believe. I'm thinking there's one more category of relative. I think that's it. So, and child and parent. So, child includes a stepchild, and parent could include a step parent. This was the first time that I can at least remember that for cancellation of removal that I had it approved for a step parent. So how did we do it? Well, this was not. There's some not weird things. There's some interesting issues in this case that we're going to talk about. But let's talk about really what the crux of the case was. It wasn't a hard case when it came to the extreme and unusual hardship in general. And that was because, unfortunately, one of the couple has three, like I said, 3 U.S. citizen children. One is a stepchild to the father. That stepchild has eye cancer, and his father lives in Atlanta, Georgia. He does not pay child support. He doesn't visit the child. So the stepdad is really essentially his father. He's grown up with him. I don't think the mom really had much of a relationship with the dad beforehand. So we had to show that, well, first we had to show that he had eye cancer. We had to get a doctor letter that showed his prognosis, his diagnosis, treatment, and prognosis. So what the problem is, how they're going to fix it, and is this something that is going to last the rest of his life, or is this something that he'll grow out of? Like a lot of people have asthma claims and they grow out of asthma, for example. That was that was, like I said, the crux of what the extreme hardship was based on. Now, that alone isn't going to do it. What you have to do is, well, you got to get that doctor letter, but then you got to show that if he goes back to Mali, he cannot get the same treatment that he can get in the US. And sometimes it's easier said than done because you're trying to prove a negative. We try to get letters from doctors in other countries to affirm we don't have this medicine, we don't have these specialists. In this case, I believe we had a letter from a doctor over there, but we also, Doctors Without Borders actually goes there to specifically to treat those certain types of cancers for kids where they don't have specialists. So we were able to show it with extrinsic evidence as well. Of course, we needed to show the 10 years physical presence and continuous presence. The good moral character evidence includes showing all the taxes were filed for at least 10 years. And like I said, the doctor letter. And then we had to show that dad really, or stepdad really was dad. Because the argument that you have is, well, okay, send dad back. You still have mom here. And the biological father for the oldest child is here. He should be paying child support. Everyone should support their children. So why can't mom stay here without dad? That's the question. But we had a letter from school confirming that dad is actually considered as the child's legal guardian. And we have plenty of evidence to show him that he took care of his son, just like his other children. He took the child with mom, and also switched off with mom, taking the child to his routine eye exam and all that type of thing. So, that was a brief overview of all the evidence, but essentially this wasn't an incredibly difficult cancellation and removal case. I should mention the hearing was in October of 2019, and now we're in April of 2023. So there's your timeline. It has grown. I think when I did this case, I remember this case like it was yesterday, but when I did this case, it was only like a 2-year wait, maybe 3-year. So it's grown, and that's a lot of that has to do with COVID. So, like I said, there are a couple of interesting issues about this case that I want to talk about. So, as I mentioned earlier, we were not the attorneys at the beginning of this case. Both mom and dad had the same attorney. They came to us, and I think it was dad who first came to us in 2015 and said, I want to switch attorneys. He wasn't happy with his. Now, I happen to know that attorney. I'm not going to say this person's name, but we've gotten a lot of clients from this attorney because this is one of those attorneys, and you really have to be careful out there who you go to, because you do not, if this is an attorney who, if he knows you've been here 10 years, he pretty much will file an asylum application, because you can't file for cancellation of removal without being in removal proceedings. And he doesn't always vet the extreme hardship claim that well. And this case happened to be a good case for that, but it's always risky putting yourself into removal proceedings. So they had to apply for asylum, and then they had to wait for it to get denied. Now, like, look at this timeline. It's crazy. They both, look at even mom. Mom applied in 2012. 2019, she gets her hearing. 2023, she's going to get a green card, which is so what is that? 11 years? I mean, that's a long time. So not only is there a risk it's not going to be granted, there's a long time. Now, there is a second issue. There's different ways of filing these types of cases, or at least from the beginning. When you file for asylum, I remember why they both filed applications, but we'll get to that. So when you file for asylum, you can have you can have derivatives, which means you can have your spouse and children under 21 on your application. If you're out of status, then the asylum office can't get denied. It can only refer you to immigration court. Now, that's really the only way to put yourself in removal proceedings, even though you're essentially, the government's still the one doing it. That's how you get the process going. Otherwise, people end up in removal proceedings, getting caught at the border, getting arrested, ways like that. And some people can be here their whole life illegally and never get put in removal proceedings. Why? That's just the way it happens sometimes. So when they filed with the previous lawyer, he had them both file their own asylum applications, even though they were married. So it could have had just mom filing the application, dad on there as a rider. And I say mom because mom at least had a colorable claim. Someone just asked on Instagram, do the wait time for the written decision is 3 years? I can't speak for every jurisdiction, but I can say in New York, this case was October of 2019. We're now in April of 2023. I'm a lawyer. I don't do math, but it's not 4 years. Yeah, it's 4.5. It's also Monday morning. My brain's not working yet. It's more than 3 years. It's about, I'd say, at least 3.5 to 4 years. Or 4.5. Oh my God, I really can't do math right now. Yeah. Okay, 3.5 years. We'll go with that. But it is taking longer than when I did the case with them. So, like I said, mom had this claim about FGM, which it was kind of a weak claim. I mean, I believe she had undergone FGM, but and you can win a claim about ongoing problems. Those are harder claims than people who escaped from getting FGM, and if they return, it would happen. Dad's asylum claim kind of said the same thing, but there was some other stuff about terrorism and whatnot. And basically, dad had the much weaker claim. Mom had a chance of getting withholding of removal, not asylum, because asylum is based on filing within 1 year. And because she filed outside the year and didn't have the excuse, she could have gotten withholding removal. Dad, on the other hand, could not have gotten withholding of removal as a derivative. So if he was on her asylum application and she got granted withholding, he'd get nothing. So that could be part of the reason they applied for his asylum. That we see happen, but again, it's very risky. Now, the second reason it became risky is because of the way it was done. And honestly, if they had come to us, we wouldn't have done it this way. We would have had both of them as derivatives on each other's application, because you can always drop one of the applications, especially if you're planning to apply for cancellation removal. This is really just a backup. So basically what happened was that they weren't very happy with their lawyer, and the dad came to us in 2015 and said he wanted to switch. And mom wasn't happy with the lawyer either, but this lawyer will charges the money up front. So I don't know what he charges, but hypothetically, let's say he says, okay, in order to handle your removal proceedings, it's going to cost $10,000. Here's your payment plan. You have to pay it all by this date, no matter when your hearing is, no matter how many hearings you have. For us, we do it a little differently. We do not require you to pay for anything until it happens. Meaning, if you apply for asylum within a year, you pay for us to prepare the asylum application. Maybe you pay for us to go to the interview with you when you get the interview notice. And once you get, and then if you do get put into removal proceedings, then we'd say, okay, this is what this hearing will cost. This is what this hearing will cost. Depending on what we have to do in your case, it's going to cost a different amount of money. And the reason is we try to be fair, and be like, we don't know when your case is going to be. We don't know how much time it's going to take. And we try to make it fair for everybody and stay in business at the same time. So, but paying in advance also can create problems, because we don't like giving refunds. Once in a while, it's rare for us to be asked for a refund, to be honest. I don't know if that's the same with other lawyers, but it's not just about giving refunds. It's just that once you have the client's money and you haven't done the work yet, you have to give it back if they want it back, which is perfectly fine. But, we're not a bank. We don't need to hold your money. And you do have the freedom to switch lawyers, and it just makes everything easier. So, but mom this lawyer wasn't that easy to get the money back from and to deal with. So mom at first did not switch lawyers because she didn't want to pay again. So the first individual's hearing was scheduled, I believe it was 2018. I attended the hearing, and I attended the hearing, and a lawyer from this person's office attended the hearing. Someone thinks they know the lawyer. Well, let's not say their name if we do know. But I attended the hearing, and you never have two attorneys at a hearing. I will say this, which I really hope doesn't give it away, of who this lawyer is or who the other lawyer is. But the lawyer sent from this lawyer's office is now an immigration judge, which I thought was a little funny tidbit to throw in there. So we show up, and the judge says to both of us, well, who's the lawyer? And we're like, I'm dad's lawyer, she's mom's lawyer, but it's the same case. And the judge was like, okay, you guys, your clients need to decide who's going to be their lawyer. It's one of you or the other. It can't be both of you. So we said, okay, well, it's up to you guys. What do you want to do? So they went back and they talked about it, and it kind of was the same issue, that mom was like, I don't want to stay with this person, but I can't afford to pay more money. He won't give me back my money. And we don't really get involved with money issues with other lawyers because it's just sticky, and that's not our job. So she went and she dealt with it with the other lawyer eventually, and they ended up hiring us. So, and what I told my client, which at that point was just a stepdad, the other option that we had was splitting the case up, having mom's case go on separately from dad's case, mom getting represented by the other attorney and dad getting represented by us. It might have been a different judge. It might have stayed with the same, but it would have been different times, different hearings. But the problem was, if mom went first and she had filed first, so she likely would have gone first, and she got granted cancellation of removal, dad stepdad, I should say, is going to have a much harder time getting cancellation removal granted, because one of the things I didn't exactly mention earlier, talking about requirements, when you talk about the extreme and unusual hardship that you need to show to the qualifying relative, that extreme and unusual hardship has to be present whether you remain in the U.S. Whether your qualifying relative remains in the U.S. without you, or the qualifying relative leaves the country with you. So it weakens the argument when there's another parent here who is in lawful immigration status that can take care of the child. It doesn't mean they can take care of the child alone, and that's not the only factor, of course, but it definitely weakens it. And the other part of it was, if it were reversed, if dad went first, mom had the withholding of removal claim to fall back on. And like I said, it wasn't the strongest one, but I've had plenty of those granted. And the Second Circuit case law says that FGM can constitute ongoing harm. And I know how to win those cases. So I said, at least she has a backup. And in that situation, if he got his green card, eventual citizenship, then he could have filed for her, and eventually she could have reopened her withholding of removal order, gotten her green card. I know that's all very complicated. That's not what this case is about, but this is the conversation I was having with the client. And I said, the best thing that we can do is have these cases together, because both of you were involved in this child's life. Both of you are integral in his life, and he can't leave you both. The whole theory was neither of you can stay here without the other. You need to work. You both need to work, but you also both need to be able to take him to his appointments and take care of him. And the easier part was, there was no question he couldn't go to Mali and get the treatment he needed. He had some serious eye cancer. He had some surgeries. It was something he was going to live with the rest of his life. I also remember this case. This is one, again, I can't say the judge's name, one of my favorite judges. I've had a lot of cases before, and she's been around for a long time. And I don't know if you could see, on one of the cameras, you could see, I'll hold it up. Essentially, when I came into court, I gave her something that looked a lot like this, which is a lot of paperwork, because when you're giving medical records, there's a lot. And she looked at me and she's like, Ms. Schaefer, I don't want that. She's like, what are you doing? She's like, just get me a doctor letter with it. It says the diagnosis, treatment, and prognosis. And I was like, okay, no problem. You still do, I always still bring the medical records to this day. But, a lot of times I talk about how you win on the papers before you even walk in, or you put yourself in the position to win at least. And I did that when you show that much paperwork. And this isn't like just filler paperwork, country condition stuff. It was medical records, because he had to go to the doctor so often. And that's kind of was the point. So the hearing ended up really not being too hard. Both mom and the stepdad testified, and we did have to prove that the other father wasn't involved in all of that. But essentially, at the end of the case, as with all cancellation or removal cases, the judge that end up getting granted, the judge said a decision could not be made today because there's no visa number available. We'll send you a written decision. Sometimes they schedule you to come back in to hear the decision. It's judge dependent when the visa number is available. And of course, the judge doesn't know when the visa number is going to be available. COVID slowed things down. So these clients have been waiting for a very long time to get their decision. But I was thrilled this morning to open the mail and see that they were both granted. And, you just never know when you're going to get it. And especially to start Monday off this way was really great. And now these two people do not have to worry about their son and about having to go back to their country. They're going to get their green card, their 10-year green card in the mail, hopefully within the next 2 weeks. Hopefully they don't have to make an InfoPass appointment. We're going to knock on wood that everything goes smoothly for them from here on out. And then they will be eligible for citizenship in 5 years from getting their green card. So, what have we learned here? Number one, you are entitled to the attorney of your choice. If you have paid an upfront fee and your attorney has not earned that fee, and by earn it, I mean hasn't done the work for that full fee yet, because sometimes you do pay the attorney money up front, and you want to switch attorneys, you have a right to get that money back. Sometimes you have to be firm, and you have to be, go to their office and stuff, but you get to choose your attorney. And that shouldn't, I'm not trying to dissuade anyone from signing an agreement like that. That's okay. You might end up, sometimes it saves you money, sometimes it doesn't. It all depends. But the point is that you shouldn't feel tied to the attorney because of that. The second thing is stepdads can get granted cancellation. Step parents and step children can get granted cancellation of removal, but you do have to show they have the requisite relationship. If the child who had the hardship lived with the biological father, there would have been probably no case for either of them. Maybe mom still had a case if she visited regularly and provided child support, because then the argument is she couldn't see her kid. But basically, you have to be able to show how, and the client had to testify how involved he was in the child's life. And then lastly, the last thing that is important here is that both mom and dad were granted cancellation of removal. And, it's funny too, when these clients first came to us, this was back in 2015, like I said, we were like very doubtful it could be granted for both parents. We had it happen before, but it was incredibly rare. And it still is incredibly rare because, again, now you're adding another layer on top of it saying, okay, all right, great. One parent can grant the cancellation removal. So now you have to prove why the other parent needs it equally as well. So in this case, mom was the biological mother. She's going to get it granted over the non-biological father. But so we had to show how important the father was in the child's life, in the mom's life, in the other two kids' lives, and how mom couldn't stay here without him, which meant that the child who had eye cancer couldn't stay here without them. So that is all today for notable approvals. And again, I'm going to redo the math in my head. Let's see. We have 3 years, 4 years, 3.5 years for cancellation removal, about. That's how long it took. So to answer the question I was asked, if it was 3 years, it looked like in New York, at least 3.5 years. And if your case was after this, then it's likely to grow a little bit more. It never seems to go down, the numbers, because it is a set number every year. So the numbers seem to grow a little bit more. But if you had your case in the last 2 years, you probably have a little bit more time to wait. So that is all today for notable approvals. I know it's nice and early Monday morning. I'm not sure I've woken up myself, but I was so excited to get the mail and see this that I had to hop on here and talk about this case, because I've been waiting for this decision for a long time. I got some more cancellation cases that should be coming through soon too that I can't wait to talk about. If you have a cancellation of removal case, are on YouTube and Facebook. Our contact information is scrolling across the bottom of the screen. On Instagram, if you go to our bio page, you can find our contact information there. We're happy to help if you have a cancellation claim or any type of immigration case for that matter. Please do not hesitate to reach out. Make sure to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If this video was helpful for you, or you know someone who it is helpful for, go ahead, click that share button so we can spread all this hopefully good and helpful information. So that is all for now. Thank you all for watching, and have a great day.